Hello everyone, this is Mahek UPADHAYay, a legal internet LEXIS and company. Welcome back to our channel. So today, this video would be on a case analysis of one case named NEWAZ versus NANKOO 1926 case. It is. This case revolves around Section 13 and Section 14 of Transfer of Property Act. Section 13 is about how a transfer could be made in the favor of an unborn child, while Section 14 talks about rule of perpetuity. It bars a person to create an unrestrictable interest, life interest in the favor of a person. It limits for how long a life interest could be created. So let's start with the facts of the case. Facts of the case are very simple. There was this Ram Charan who owns some agricultural land. So the dispute is about this too big a land of him. He created a sale deed executed in the favor of this NANKOO. So NANKOO said in the favor of a NANKOO, one of the clause of this deed was that until the life that the possession of this 2 biga would remain with the Ram Charan till his life, and after his death the possession would be handed over to his son without the payment of any rent or any government revenue. Then after his son's death, some other male linear descendants of his family, if there is no linear descendant left, then the whole land, the 2 biga land would be held into the possession of this NANKOO. So it was one of the higher of this Ram Charan who filed this suit for claiming that the clause is a valid clause in contravention of Section 13 because this deed do not create an absolute ownership or absolute interest in the favor of this son of Ram Charan. So this clause is void, and further it is also in contravention of rule of perpetuity as it mentioned in Section 14 of TPA. Court held that what happened further in this case was the Ram Charan son died. The Ram Charan died. Later, his son even died childless. So, as per the clause, the whole property, the 2 biga, was gone into the possession. Was now owned by the vendee. That means NANKOO. Who now hold the possession of the whole property. So the higher of this Ram Charan go to the suit, and the court said that here it was just a case where the family has no male legal descendant at such early stage. Otherwise this condition could have come after hundred of years, and such situation is in contravention of rule of perpetuity. So the interest in favor of the interest created, life interest created for an eternal time is of no use, and so cannot be regarded as a valid clause. So the possession was handed over to the higher of the Ram Charan as the case was decided in his favor. This was all about the case. Hope you like this video. Thank you.